Welcome to the deep dive. Today we're tackling, well, probably the most foundational case in American tort law, Palsgraf v. Long Island Railroad. It's maybe one of the most frustrating, too.
Absolutely. It's got everything, bizarre facts, brilliant legal minds clashing.
And our mission today is really to get to the bottom of legal limits. You know, when an act of just basic carelessness, like helping someone onto a train, triggers this unbelievable, catastrophic chain reaction, where does the law actually draw the line? Who's responsible?
It forces you, really, to pick between two very powerful competing ways of looking at negligence. You've got Chief Judge Cardozo for the majority, and then Judge Andrews with this fiery dissent.
Two completely different structures.
Exactly. And the tension is almost philosophical, which is why we're still talking about it almost 100 years later.
Okay, so let's set our path. This is crucial, I think, for anyone trying to grasp negligence analysis. The core problem for you listening is this. Is liability limited right at the start by what the defendant should have foreseen? Is it all about duty? Or is it that once you're careless, liability just flows outwards, and we only cut it off later based on how, I don't know, indirect or remote the consequences seem, making it a question of proximate cause?
That's the split we're going to model.
Yeah.
We'll follow two distinct paths. First, Cardozo's majority view, that tight, foreseeable plaintiff rule. It acts like a strong filter, focusing entirely on duty.
Okay.
Then, if we pass that filter, or if we just adopt the dissent's view from the start, we'll shift to Judge Andrews. His idea is this expansive duty to the world at large, which then puts all the weight on that later, much messier analysis of proximate cause.
And we'll break it down element by element.
Step by step, just like you'd structure a legal argument.
All right, let's dive in with the majority then. Chief Judge Cardozo, what's his fundamental rule, his starting point for duty?
Cardozo's big idea is that negligence is fundamentally relative. It's not some abstract wrong floating out there.
Relative, meaning?
Meaning, it's not actionable unless it involves invading a legally protected interest of the plaintiff. The plaintiff has to show a violation of a right that's personal to her.
Okay.
So he defines the scope of duty using foreseeability right at the very beginning. His famous line is, "The risk reasonably to be perceived defines the duty to be obeyed." And risk imports relation. It is risk to another or to others within the range of apprehension. Duty is tied to who you could foreseeably hurt.
That sounds incredibly precise, almost surgical. So if you couldn't reasonably see the danger to this specific person, Mrs. Palsgraf in this case, you didn't owe her a duty, even if your act was careless towards someone else.
Exactly. You only owe a duty to people within that foreseeable range of apprehension. He makes duty strictly personal, strictly relational. It's not owed to the world at large.
Okay, let's apply this strict rule. Let's analyze Palsgraf. First, what are the legally dispositive facts? Just give us the essentials of this wild scenario.
Right, so you have a train platform. This is Palsgraf. The plaintiff is standing quite a distance away from where people are boarding. She'd already bought her ticket.
Okay.
Meanwhile, two railroad guards are trying to help a passenger who's running late get onto a moving train. This passenger is carrying a package wrapped in newspaper, or small. As they help him, one guard pushes, one pulls, and they dislodge the package. It falls onto the tracks. And then, boom, it explodes.
Explodes.
Yeah, it turns out it contained fireworks.
Yeah.
But crucially, the guards had no idea. The package looked harmless.
Not Mrs. Palsgraf.
The explosion shockwave travels down the platform, knocks over these heavy-weighing scales many feet away, and the scales fall on Mrs. Palsgraf, injuring her.
Just unbelievable. So, given those facts, what was the core legal issue for Cardozo and the majority? Could the railroad possibly be responsible for that chain of events?
The precise legal question was this. Was the conduct of the railroad guards, which, remember, only seemed to threaten the passenger's property, the package, was that conduct a wrong in relation to Mrs. Palsgraf, standing way over there, such that the railroad owed her the duty of care in the first place?
Okay. What rule of law did the court apply to answer that? You mentioned his general principle, but what's the black letter rule here, and what are its testable elements?
The rule, as Cardozo frames it, is that negligence and duty are strictly correlative. You have to show a wrong to yourself, the plaintiff, not just point to a wrong to someone else.
Right.
And this breaks down into two key operational elements for deciding if a duty exists. First was a hazard, apparent to the eye of ordinary vigilance, and second was the plaintiff within the range of apprehension of the defendant's act.
Got it. Apparent hazard, range of apprehension. Now for the court's elemental analysis. Let's walk through this. How did the court apply the first element, apparent hazard?
Okay, so the sub-rule here is that the act must involve an unreasonable hazard that bodily injury might follow. Applying that, Cardozo really focused on how the package looked. He said it could have been abandoned waste, just newspapers.
Nothing obviously dangerous.
Exactly. The key point for him was that the initial carelessness, helping the passenger, only seemed to risk a wrong to a property interest only, meaning damage to the package itself. So, the court's conclusion on this element,
Yeah.
no hazard regarding Mrs. Palsgraf's bodily security was apparent from the guard's actions.
Understood. So maybe careless towards the package, but not apparently dangerous to people standing far away. Now, what about the second element, range of apprehension?
Right. The sub-rule here is that the orbit of danger, what a reasonable person would perceive as the zone of risk, defines the orbit of duty. Cardozo's reasoning here is that the explosion itself was completely unpredictable. He uses an analogy. If a guard trips over what looks like waste, but is actually dynamite, a passenger at the other end of the platform isn't owed a duty because they're just too far removed from that initial, seemingly minor act.
So the falling package.
The falling package, Cardozo says, had no potency of peril to persons thus removed. It didn't signal danger at that distance. So the conclusion on this element, Mrs. Palsgraf was simply outside the range of apprehension of the guard's original negligent act.
So after analyzing both elements, no apparent hazard to her, and she was outside the range of apprehension, what was the court's final conclusion? She was undeniably injured by the explosion, but she loses.
She loses. The judgment for her was reversed and the complaint dismissed. Because Cardozo found no duty was owed to Mrs. Palsgraf, the entire negligence claim failed right at the first step. And he drives the point home, saying, "The law of causation, remote or proximate, is thus foreign to the case before us." Meaning, if there's no duty, we don't even need to talk about whether the guard's actions caused her injury.
That feels stark. It seems to cut off liability very early, regardless of the actual chain of events. I mean, the explosion did happen. The scales did fall on her because of the guard's actions. It feels tough on Mrs. Palsgraf.
It is tough, and that's the heart of the debate. Cardozo is clearly prioritizing foreseeability and arguably protecting actors from potentially limitless liability chains. He's drawing a tight circle.
He uses some examples to make this point, right? About how wrongfulness is relative.
Yes, very vivid ones. They really help clarify this idea that an act that's wrongful to one person might not be wrongful to another.
Okay, take his reckless driving example. Driving recklessly on a crowded city street, clearly negligent, right? Risk is obvious.
Right.
But what if you do the exact same act, same speed, same recklessness, but on a private speedway or a race course? What happens then?
Cardozo says the act would lose its wrongful quality on the speedway. Why? Because the eye of vigilance, the reasonable person, no longer perceives a risk of damage to other innocent travelers. The context removes the foreseeable victims.
So the duty vanishes because the foreseeable risk vanishes.
Precisely. It highlights the relativity. Risk must be perceived in relation to specific others.
And then there's this other really striking example, the bomb analogy. If someone jostles a neighbor in a crowd, just a normal bump, but unknown to the jostler, the neighbor's carrying a hidden bomb and the jostle makes him drop it and it explodes. Is the jostler liable to people injured way out at the outer fringe of the crowd?
Cardozo says no. The wrongdoer to those distant victims isn't the person who accidentally jostled the bomb carrier, it's the person who brought the bomb in the first place. The person who explodes it without suspicion of the danger isn't liable for those unforeseeable consequences. Foreseeability of the danger itself is the key that limits the duty, and therefore the liability. He warns against requiring prevision so extravagant that it would paralyze everyday life.
Okay, so Cardozo builds this high wall called duty, based on foreseeable risk to a specific plaintiff. If you don't get over that wall, your case is over before it starts.
That's a good way to put it.
Now let's shift gears completely. Judge Andrews, in his dissent, basically says Cardozo's wall is built in the wrong place. He argues the majority's view of duty is too narrow. What's his fundamental rule? How does he see duty?
Andrews throws the door wide open on duty. He completely rejects the idea that duty is relative only to the foreseeable plaintiff. His starting point is much broader.
How broad?
He states, everyone owes to the world at large the duty of refraining from those acts that may unreasonably threaten the safety of others.
Wow, okay. Duty to the world. So if your act is unreasonably risky to anyone, you've breached a duty to everyone.
Essentially, yes. If an act unreasonably jeopardizes anyone's safety, it's considered a wrong against society, a breach of this general duty. For Andrews, the question isn't really if there's a duty there, almost always is if you act carelessly. The real question comes later. Proximate cause.
So under Andrews, the guards helping the passenger were negligent towards society generally, including Mrs. Palsgraf, because their act was potentially unsafe.
Yes, he'd say a duty was owed. The analysis then shifts entirely.
Okay, let's revisit the Palsgraf facts again, but this time through Andrews' lens, focusing on proximate cause. What was the core legal issue for the dissent?
For Andrews, the issue wasn't duty. It was the injury to Mrs. Palsgraf so connected with the initial negligent act, the guards knocking the package, that the act can be fairly called the proximate cause for injury, even though the chain of events was bizarre and unforeseeable in its specifics.
Right. So how do we determine that connection? What rule of law governs proximate cause under Andrews' theory, and what are the factors he uses to test it?
Andrews is quite candid that proximate cause isn't about strict logic. He calls it a matter of convenience, of public policy, of a rough sense of justice. It's basically a tool courts use to decide, somewhat arbitrarily, where to cut off liability in a long chain of events.
So it's a flexible, policy-driven.
Very much so. Since he has this broad view of duty, he needs a flexible backstop. He suggests several factors. You could think of them as elements to consider to guide this judgment.
Okay, what are they?
1. Was there a natural and continuous sequence between the cause and the effect? 2. Was the negligence a substantial factor in producing the injury? 3. Was the result too remote in time and space? And 4. The tricky one. Prudent foresight. Could the result or type of injury be reasonably foreseen, maybe not from the initial act, but flowing from its immediate consequences?
That sounds less like a hard rule and more like a checklist for a jury's gut feeling about fairness. Let's analyze using these factors. How did the dissent apply the first two? Natural and continuous sequence and substantial factor.
Okay, the sub-rule here is basically, but for causation was the negligence necessary for the harm. Andrews found this easy. He argued the explosion was, without dispute, the direct cause of Mrs. Palsgraf's injuries.
Right.
And it was clearly a substantial factor. The only thing in between was the scales falling, but that was just a direct physical result of the explosion's concussion. So his conclusion on these, both factors easily met. There was a direct, unbroken chain.
Okay, clear enough. Next, how did the dissent address remoteness in time and space? Was she too far away?
The underlying idea is that the further away in time or space, the more likely other causes might intervene. But Andrews looked at the facts. Mrs. Palsgraf was standing, he says, apparently 25 or 30 feet, perhaps less, away.
Not exactly the other end of the station.
No. He concluded there was no remoteness in time, little in space. Especially given the force of an explosion, that distance wasn't enough, in his view, to automatically cut off liability as a matter of law.
All right, now for the trickiest one, maybe. Prudent foresight in the proximate cause analysis. How does foreseeability play into Andrews' view, if not for duty?
This is where it gets subtle. The sub-rule acknowledges that while initial negligence is judged by foreseeable risk, was the act careless, the natural results flowing from that negligence do bear on proximate cause.
Meaning?
Andrews reasoned like this. Okay, maybe the guards couldn't foresee an explosion from dropping a newspaper-wrapped package. But given that an explosion did occur as a result of their carelessness, he argues it required no great foresight to predict that the natural result of such an explosion on a train platform would be to injure someone nearby. Injury of some kind from fragments, falling glass, or, yes, wreckage of machines like scales was most probable once that explosion happened.
So foreseeability of the type of harm resulting from the immediate dangerous event, the explosion, not necessarily foreseeability from the very start, dropping the package.
Exactly. He concluded the injury was foreseeable enough within the stream of events that followed the negligence.
So Andrews saw this whole thing very differently. What was the dissent's ultimate conclusion on the case?
He argued forcefully that he cannot say, as a matter of law, that Mrs. Palsgraf's injuries were not the proximate result of the railroad's negligence. For him, it was a classic jury question.
Let the jury decide based on common sense.
Precisely. He concluded the jury's verdict for Mrs. Palsgraf should have been upheld. It was their job to apply that rough sense of justice, guided by policy and common sense about the directness of the harm.
Okay, this case presents two fundamentally different ways to analyze negligence when things go unexpectedly wrong. Cardozo stops you at the duty gate if the plaintiff wasn't foreseeable. Andrews lets you through the gate but might stop you later with the flexible proximate cause factors.
That's the core conflict.
So for our listener who needs practical tools, how do we synthesize these? We need a diagnostic checklist, right? Something you can use when you encounter a negligence problem with remote or bizarre injuries.
Absolutely. We can build a step-by-step framework that forces you to consider both approaches, which is vital for issue spotting on an exam or analyzing a real case.
Yes.
It tells you how to tackle any negligence problem involving a weird chain of events. Lay it out for us. Step 1. Step 1. The initial act. First, just identify the defendant's action. Was it negligent at all? Did it unreasonably threaten anyone's safety? This is basically Andrew's starting point. Were the railroad guards acting carelessly when helping the passenger? Probably yes.
Okay, so first establish some underlying carelessness. Then what?
Step 2. The Cardozo filter duty. Immediately apply Cardozo's test. Ask, was this specific victim a foreseeable plaintiff? Was she within the orbit of danger created by that initial careless act?
And if the answer is no,
If the answer is no, like the majority decided for Mrs. Palsgraf, then under Cardozo's view, the analysis stops. No duty, no liability. End of story. That's the narrow path.
but what if the plaintiff was foreseeable? Or what if you're in a jurisdiction that follows Andrews's broader view of duty?
Step 3. The Andrews stream, proximate cause. If duty is established, either because the plaintiff was foreseeable, because the jurisdiction uses Andrews' broad duty rule, then you move to proximate cause. This is where you analyze the chain of events itself.
This is where we look at how connected the harm was to the act.
Exactly. You're acknowledging that a careless act happened and caused harm, but now you're asking, should we draw a line anyway, based on policy and fairness?
And how do we test that?
Step 4. Proximate cause factors. Now, you systematically apply those Andrews factors we discussed. Was there a natural and continuous sequence? Was the negligence a substantial factor? Was the harm too remote in space or time? And, crucially, was the type of harm that occurred foreseeable, considering the immediate results of the negligent act, like the explosion?
So you check duty first, Cardozo's filter, and then you check the chain of causation using the Andrews factors.
Right. This two-stage analysis ensures you cover both the initial relationship and the subsequent consequences. It forces you to grapple with both major theories from Palsgraf.
We've definitely unpacked one of the toughest, most intellectually challenging debates in tort law. That fundamental split is negligence defined by duty to a foreseeable plaintiff, or by the stream of consequences analyzed through proximate cause.
And it's not just history. Jurisdictions today still lean one way or the other, or blend the approaches. Understanding both is key.
Which brings us to a final provocative thought.
Cardozo's majority opinion seems driven by a desire to limit liability, to prevent what he called prevision so extravagant, protecting actors from unpredictable outcomes. Andrews' dissent seems more focused on ensuring compensation for someone directly harmed by carelessness, calling it a matter of expediency and public policy.
So the question for you to ponder is, what's the primary goal here? Is it drawing clear, predictable lines to protect people acting in the world from potentially ruinous liability for fluke accidents? Or is it ensuring that when someone is injured as a direct, albeit unusual result of another's carelessness, they should recover? Where should the balance lie?
That debate between protecting the actor and compensating the victim in these hard cases is really what Palsgraf is all about, and it's a debate that's still very much alive in the law today.